How the city got there in 2 documents so far, and now they're going to look to do a third. They could do 300. It won't matter. You can't change what is a fact. And what that is that in the first filing, December 4th, the city stated that the substation was not permitted in the M1 zone. They stated that the battery, the BESS, was a conditional use in the M2 zone. And then they had a couple others. The bottom line is that their position was, if you read the code, these things are not permitted. Okay, so what we did is we filed, by the way, some of the people said that I was representing the county. No, I was sued. 9 other people were sued, all the landowners. I'm a lawyer and I represent all of them. So we were what's called the real party in interest, and the county was there. That was pretty simple. It's exactly what I told the judge when he said, make your appearance. My appearance was on behalf of the real parties in interest. So I saw that as one comment, and it's just always, we're always dealing with bad facts. Anyways, the gist of the lawsuit, which was sworn under oath by the city manager, Dennis Morita, was that these zoning codes were misinterpreted by the county. So the fight was not about how we feel, meaning the city, over the land use and how we feel about air. Was there a violation of the code? It was that simple. So what a judgment on the pleadings, which is what the court heard, real impressive, really impressed with the judge. Not because we prevailed, just that he was very thorough. You could see he spent a lot of time. He knew the code better than us lawyers. I could tell, it was impressive. So the gist of it was, is this correct? And so in judgment on the pleadings, one of the things you get to do is you get to tell the court, assume everything they said is true. That's what was before the judge. However, the ones that are in the code that are false, you get to strip those out and take it out. And that's what we did. We said, look, some of these statements are just pure false. Just read the code. It's not there. And our position was, once you strip out the code by the false statements, you can call them misrepresentations. If you were a kid, you would call them a lie. Once those were stripped out, there was nothing left. It was just other people, how they felt. And you don't get to do that with CEQA. So that's what we did, and that's what we prevailed upon. What that means is that the city's position that the land is not permitted use for a data center was false. It just doesn't exist in the code. Now, more importantly, on September 4th of last year, the county had made a determination in a letter that it was a permitted use. And that's basically what they do, is they do these determinations. Now, if you ask yourself, who gets to determine the code? It's not going to be your neighbor's city. It's going to be you, the county. So the county correctly interpreted the code. The court agreed with us, and that's why their petition was dismissed. Now, they get to amend, but here's the question. Why keep wasting time? What do you do with an amendment? In an amendment, you got to go back and you got to say that something was not proper. You got to still go back and say that the utility was not a permitted use. But that's the code. It's there.
How many times have they amended?
Well, they've amended twice. So I should rephrase. They have 2 petitions. They amended once. So what happened was, when they filed the December 4th one, we did what's called a meet and confer, where we notified them that we were going to move for judgment on the pleadings. And part of the process is you meet with the other side to see if you can get resolution. I actually sent them a copy of the draft motion for judgment on the pleadings, which I'm told is kind of not normal, but hey, I was confident in my case. And then they decided to amend. When they amended, the second one was probably about 40% longer. But here's the problem. If the code says that a utility, substation utility, is a permitted use, how do you get there to say it isn't? You can't. On the batteries, the reason it was determined to be a ancillary use is that it's not exporting to the grid. Its only supply is to the data center. So that was the reason for that determination from the county. So what we get in court is no different than what you see on the media. Is a lot of stuff that's just false. And now the city has went to the public, and there's a few more things I want to talk about in the lawsuit, to say that, they're energized because they get to amend. Really, that's amazing.